everyone, and welcome back to our weekly webinar series. Today, we are having our episode number 141, and we're talking about 12A, a very important part of IBC and a very important part of rather success of IBC is also in many ways seen as to what kind of success has people achieved through 12A. Over to Anil sir.
Thank you, Ankit. Welcome to our audience. Weekly high that we get in conducting this webinars, that is somehow had inculcated in our life, in our habits. A team makes the efforts. Then Saturday morning, starting at 5 a.m., missing the morning walk schedule, missing those people, those friends who are playing golf, and they're missing me. All this because this is more enjoyable and this is a passion now. So this 141st episode is in fact is only because of this habit that we have now inculcated in our life. And thanks to Ankit family that this is continuing. Yes, the subject that we have chosen today, as Ankit has already described, it is the trajectory of section 12A under IBC. The insertion, what was the background when it was inserted under IBC, and how it has finally flowed till the last judgment. One, which was very important, that was in the case of Byju's withdrawal case, and the name of the judgment was Glass. Now, even after Glass, there has been some comments from the Supreme Court in the case of Jet Airways. That was also saying that although this judgment of Byju's withdrawal that has said many things, and especially where there is a statutory framework, statutory provisions. If there is a framework, if there are provisions, then leaving all those things behind and using the law of natural justice or the powers that the courts are having for providing natural justice, that can still be used. This is after the Byju's judgment. So let us try to understand how this birth of section 12A in fact took place in IBC. Now we are basically discussing the it was a gap in the IBC framework, that there was no provision for withdrawal of insolvency proceedings post admission, and that was also under specific conditions. That like when this law started, it was only a default of 1 lakh of rupees that you can go to file an insolvency application under section 9, and any company can go for insolvency, and there was no provision post admission where the withdrawal was possible, even if the parties have settled outside the court. That kind of withdrawal, there was no provision, and there was no section 12A, there was no section 30 capital A of CIRP regulations. No, so therefore, we will analyze the various Supreme Court and various NCLAT decisions on this subject, how this was required in the law, how this was finally inserted, and how this trajectory flows, and what is the present situation. So when this, in fact, when we see there was no provision under the IBC, then the courts, including NCLT and NCLAT, they were constrained from permitting such withdrawals due to absence of specific reasons in IBC as a temporary solution. It was considered as a temporary solution, and the tribunals invoked Rule 11 of NCLT Rules 2016 and same Rule 11 of NCLAT Rules 2016. It is a coincidence that in both the rules, the rule number is 11 in both these rules. Both deals with the kind of uh, 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 to meet ends of justice and to prevent abuse of the process of tribunal. Let me read Rule 11 of NCLT rules and Rule 11 of NCLAT rules, which has a similar language. What it says, nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the tribunal. In NCLAT rules, it is appellate tribunal, to make such orders as may be necessary for meeting the ends of justice or to prevent abuse of the process of the tribunal or appellate tribunal. So there are two objectives. One is the ends of justice, or to prevent the abuse of the process of tribunal or appellate tribunal. So these were the rules 11, and in fact, Supreme Court held back in 2017 in the case of Uttara Foods and Feeds Private Limited versus Mona Pharmachem. So now, from now onwards, whenever I would be uh, citing a name of the judgment, I would be repeating that. So in case there is any person who actually is noting down, even otherwise, the recording of my videos can be seen after 2 hours on the YouTube channel of AAA Insolvency. And in case you would subscribe to that channel, the notification will automatically come to you that this particular recording has been uploaded on YouTube channel. So the Supreme Court judgment in 2017, Uttara Foods and Feed Private Limited versus Mona Pharmachem, and in this case, the Supreme Court held and in fact underlined a crucial gap in the IBC framework. It recognizes that once insolvency proceedings were admitted, there was no statutory provision allowing their withdrawal, even if all the stakeholders reached an amicable settlement. Therefore, the court, exercising powers under Article 142 of the Constitution, set aside the NCLAT order, emphasizing the need for inherent powers to facilitate settlements post-admission. The judgment catalyzed reforms, urging the inclusion of provision to avoid unnecessary appeals and enable amicable solutions. So this particular judgment of Honorable Supreme Court, in fact, was instrumental in bringing this reform in IBC to fill this gap of having any kind of withdrawal provision. That was the judgment in 2017, and that another judgment again on 24th of July 2017, that was Lokhandwala Kataria Construction versus Nisus Finance and Investment Managers LLP. Lokhandwala Kataria Constructions versus Nisus Finance and Investment Managers LLP, again long back in 2017 by Honorable Supreme Court India. It was said again, the Supreme Court raised a very pivotal legal question. Can NCLAT exercise its inherent powers under Rule 11 of NCLAT Rules 2016 to approve a compromise between parties after the admission of an insolvency petition? This was the matter which was decided again, second time, by the Honorable Supreme Court. First judgment was the Uttara Foods and Feeds Private Limited in 2017, and then second judgment was in July 24, 2017. Now, Supreme Court held in this case, in the case of Lokhandwala Kataria Construction, the Supreme Court held as under 1. The Supreme Court disagreed with the NCLAT refusal to allow the settlement, noting that the situation called for exceptional intervention. Second, exercising its power under Article 142 of the Constitution, the court approved the settlement to resolve the dispute and dispose of the appeal. Court also emphasized the need for legislative changes to introduce a structured mechanism for withdrawal post-admission to avoid similar scenarios in the future. So these are the two judgments which is Lokhandwala Kataria and Otara Food. And actually, these were instrumental in finally, when this insolvency law committee, in fact, was forced to discuss this issue, deliberate on this issue, and present a report to the lawmakers. So therefore, in March 28, Insolvency Law Committee, in fact, observed in this scenario, and that was the committee says under Rule 8 of the uh, Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016, the NCLT could permit withdrawal of an insolvency only before its admission upon the applicant's request. Only before its admission by adjudicating authority. That is what Rule 8 says. Post-admission withdrawals were not covered under IBC or CIRP regulations, leaving courts to grant such withdrawals on an ad hoc basis. That was the observation by the Insolvency Law Committee in the report dated March 2018. Judicial practice is reviewed, in fact, in this particular Insolvency Law Committee report. This Lokhandwala Kotaria and Otara Food was also discussed. However, the Insolvency Law Committee recognized that CIRP is not a private dispute, a resolution mechanism between a single creditor and the corporator, but it involves all creditors of the debtor. So, ILC, Insolvency Law Committee, said that the CIRP as such is not something which is possible to, which can be used for recovery. It has to see whether the company is solvent or insolvent. If somebody has reported, maybe worker, maybe operational creditors have reported that this company is unable to pay, let the entire world know. Let all the other creditors know whether this company is financially sound or not. The principle is fundamental to ensuring equitable treatment and achieving the objectives of the court. Not only one person can be settled out of the court. Therefore, the committee recommended that the withdrawal post-admission should be permitted only if the approval by the committee of creditors with a 90% majority that was recommended. And this proposal from ILC ensured that settlements post-admission would involve the participation and agreement of all stakeholders, not just the applicant, creditor, and corporate debtor, aligning with the IBC's intent to avoid preferential treatment and maintain the collective process of insolvency process. Therefore, the committee advised using Rule 11 of NCLT Rules 2018 as a substitute for this issue. The committee advised that till the time any framework is made, any provisions are amended, this particular Rule 11 of NCLT rules or NCLAT rules 2016 may be used as a substitute for such provisions. Instead, it proposed an amendment to Rule 8 of the CIRP rules to institutionalize the withdrawal process, because that was only ad hoc process. However, this particular Insolvency Law Committee gave its report in March 2018, and based on this report, in fact, the Insolvency and Bankruptcy Code Second Amendment Act 2018 was promulgated, and it was effective from 6th of June 2018, and a new section was inserted, and for permitting the withdrawals post-admission approval of 90%, that was aligning with the IBC objective, and the amendment which actually came under Section 12A, a new Section 12A was inserted after Section 12, which says the adjudicating authority may allow the withdrawal of application admitted under Section 7 or 9 or Section 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditors in such manner as may be specified. So that means there was an expectation of regulations which will come, and that came finally as Regulation 30, Regulation 30, in fact. Then what happened? This particular insertion of Section 12A was challenged, and that was also decided by Honorable Supreme Court in the case of Swiss Ribbon Private Limited versus Union of India. And that was, in fact, the judgment on 25th of January 2019. That was from Justice R.F. Nariman and Justice Naveen Sinha. And in this particular case, the petitioners challenged the constitutional validity of Section 12A of IBC. Section 12A allows withdrawal of the CIRP process with the approval of 90% of the committee of creditors. The petitioners argued that this provision grants excessive power to the committee of creditors. It hampers legitimate settlements and denies stakeholders fair access to justice. They contended that requiring such a high threshold for COC approval violates constitutional principle, because once a case is admitted to insolvency, 90% of the committee will have to say yes, then only it can be withdrawn. They were saying this is too harsh. The powers to committee of creditors is too many, too high, excessive, and also it actually hampers the settlement process, and it also kind of denies the fair access to justice. So therefore, in these issues, the Supreme Court finally says that is the requirement of 90% COC approval under Section 12A is arbitrary and violative of Articles 14, 19, and 21 of the Constitution. That was the first question of law was framed in the case of Swiss Ribbon. Does Section 12A derails the insolvency process by giving unbridled discretion to the COC to block legitimate withdrawals? Finally, the question of law was that whether Section 12A of the IBC meets constitutional standard of fairness and reasonableness, or does it infringe on fundamental rights and the Constitution? And finally, the judgment came and it upheld the constitutional validity of Section 12A. It held that the insolvency proceedings are proceedings in rem. Proceedings in rem and proceedings in personam. This concept was explained in Swiss Ribbon judgment that proceedings in rem, once the proceeding starts, it becomes the proceedings against a status, against a structure. It becomes public. It becomes a proceedings for everyone, and it is not the proceedings between applicant and the respondent. That is proceedings in personam. So proceedings in rem, proceedings in personam. This particular concept was explained, and therefore it was said that it is impacting, once it is admitted, it is impacting all the stakeholders. Post admission, withdrawal cannot be permitted solely on the applicant's discretion, as it may harm creditors collectively. The committee of creditors representing creditors is best suited to decide on the viability of such withdrawals. The requirement of 90% COC approval ensures collective decision-making and fairness. The court emphasized that provision is not arbitrary and is consistent with the objectives of the IBC, such as time-bound resolution, maximizing the asset value. Therefore, Section 12A does not violate Article 14, 19, or 21 of the Constitution. And second time after this Swiss Ribbon, there was another judgment which came from Honorable Supreme Court. That was in the case of Valal RCK versus Siva Industries and Holding Limited. Valal RCK versus Siva Industries and Holding Limited, where again the Honorable Supreme Court reiterated the principle that while commercial wisdom of the COC should generally be given priority, this does not imply absolute immunity from the judicial review. The NCLT retains the authority to intervene in cases where COC's decision appears to be arbitrary, unreasonable, or malified. This ruling highlighted the NCLT's commitment to ensure that the resolution process remains fair and just, safeguarding the interest of all the stakeholders involved in the insolvency proceedings. Now, on 25th of July 2019, 25th of July 2019, then comes the uh, after the judgment of Swiss Ribbon, when this constitutional validity of Section 12A was upheld by the Supreme Court, then IBBI started drafting the regulations, and the regulations were notified on 25th of July 2019. So whatever trajectory that we have seen so far, originally there was no uh, provision for withdrawal. Once the CIRP is admitted, there was no provision for any withdrawal. So Rule 11 of NCLT Rules 2016 and Rule 11 of NCLT Rules NCLAT Rules 2016, those were used to permit withdrawals. The courts, in fact, also said that although the withdrawal is okay, because then they also found a gap that was given in two judgments by Supreme Court, and Lokhandwala and the Lokhandwala and the so these two judgments finally, in fact, Lokhandwala and Uttara Food, those two judgments, in fact, were very important. So therefore, these two judgments finally actually uh, the government inserted Section 12A to IBC after the Insolvency Law Committee. Now, once the 12A was inserted and 90% powers were given to COC, again it was challenged, and Swiss Ribbon was the case where the constitutional validity of 12A was upheld. And then after this was upheld, then in July 2019, IBBI came up with the regulations, Regulation 30 capital A, and it said in very clear process was defined, very clear framework was defined, that of course Rule 8 of NCLT rules will be applicable for withdrawing any application before it is admission. But the Section 12A and Regulations 30 capital A is only and only applicable after the CIRP is initiated. Now, what it says, what Regulation 30 says, that if the withdrawal application has been received before the constitution of Committee of Creditors, it is to be received from the applicant, and it will be in Form FA, and that Form FA will also have enclosed a bank guarantee for the expenditures, CIRP cost, and that estimated expenditure, and up to the date of actual withdrawal, that bank guarantee would also be part of the application, which will be submitted to the RP or IRP at that time. So that was the first regulation, which says before the constitution of Committee of Creditors. Now, it also said that even the withdrawal application in Form FA can also be submitted after the COC constitution, COC constitution, and again, it will be Form FA. It will be accompanied by a bank guarantee covering the estimated expenses incurred by IRP or the IRP up to the application date, and also up to the date on which it will be accepted by the court. Then the COC, once the COC is presented, this kind of application in Form FA along with the bank guarantee, the RP will place it before the COC, and COC must deliberate on withdrawal of application within 7 days of its receipt. So within 7 days of its receipt, there must be a COC meeting, and there must be some discussion on this, and then the COC must say it is acceptable or not. That is only in case the Form FA is received after the constitution of the committee. And then the third provision says that this particular, once the committee is constituted, the case can be withdrawn only with 90% of the COC voting share. Then there was another immediately within 3 days. Once it is approved by the committee of creditors, RP or the IRP is under obligation to submit that particular withdrawal application to NCLT within 3 days. Then the adjudicating authority may permit the withdrawal after looking into all the aspects like the other creditors, etc. Even there was a provision that even the even the form FA, even the withdrawal is possible even after the constitution, but before the expression of interest that is also another section, that once the expression of interest is released, once the public notice for inviting expression of interest, means Form G, is released in the newspaper, only even in that case also the withdrawal is possible. However, it will require the kind of reasons for such a delayed withdrawal. Now, the 30A, Regulation 30A, in fact, it streamlines the process of withdrawal, ensuring timely decision-making of the COC, also safeguards creditors' interest by requiring not creditors' interest, IRP's interest by requiring a bank guarantee to cover CIRP costs. Then also it is it's a structured process where the ambiguity will be reduced and procedural fairness will be assured. Now, in this case, we have some judicial interpretations, like the Supreme Court has clarified that Regulation 30 capital A must be read in conjunction with Section 12A. That was decided by Honorable Supreme Court in Brilliant Alloys Private Limited versus S. Raja Gopal and others in 2018. Brilliant Alloys Private Limited versus S. Raja Gopal and others, and the court emphasized that the flexibility of Regulation 30A and Section 12A, allowing withdrawal applications even after the issuance of expression of interest, contrary to the strict procedural interpretation of Regulation 30A, that actually is not strict, but that is something which is good. So now in this case, here, Ankit, we have now gone ahead. Now we actually have reached a stage where we have seen the in insertion of 12A and insertion of regulations 30 capital A, and thereafter now what we have, even after the insertion of 12A, even after the insertion of 30 capital A, the Supreme Court had given few judgments. We will discuss about the judgment, whether in meantime, if there is any question which actually are coming from the audience, or in case you have to add something. Because see, what is now left, that first, even after insertion of 12A and after insertion of 30 capital A, the Supreme Court said in 3 cases that even if the mechanism is there, even if the framework is there, but still the courts can use their powers. And those things, in fact, the Supreme Court has already said, even after the insertion. In the case of Byju's also, Honorable NCLAT used those 2 judgments while allowing the withdrawal, because these 2 judgments were also from a Supreme Court even after the insertion of 12A and 30A. You would like to add, and we would like to see some of the questions.
So one question that is interesting is that can this bank guarantee be given by the CD? Is there any way that this bank guarantee is given by the CD? So that's one question from Mr. Balakrishnan. The other question that he's asking is that the beneficiary of the BG is the CD. So what is the use of such a BG to the IRP? So because the BG here is to secure the RP's fee. So
Let us,
this
Ankit, let me answer this question. First of all, the form FA has to be given by the applicant, and that may be an operational creditor or that may be a financial creditor. That has to be given by the applicant. When it comes to form FA, it has to be signed by the applicant and along with the bank guarantee. Why bank guarantee? Because one, the applicant said that the proceedings may be started, CIRP was initiated, and now he is withdrawing it. That means the entire cost which is being incurred, that would be on his account, because he first said that it should be admitted. Then he also participated in the court proceedings. Then the RP was appointed, and now he says that I want to withdraw. So who will pay the cost? And that means it is the obligation of the applicant to pay the cost. And he may recover from the company, because this is what you owe me, and this is what I have spent for realizing this money from you. So that, of course, claim that he has on the company. And in case the company pay this, because the applicant is claiming it from the company, that in case you want to settle, then you have to pay me this, and you have to pay to the RP this much, then I would say that yes, I have withdrawn this case. Now, in the case of Abhishek, and in the Supreme Court said, yes, okay, we understand that this money is paid from the account of the corporate debtor, because the IRP had not taken the control and custody of the account of the corporate debtor, and out of the operations, out of what it was given to the IRP, it was given as a bank guarantee. The court said, like, once this is given, and the case is withdrawn, and they could not take any negative view about it. And the only thing that they have written, the Supreme Court has written, that we are not looking at whether it's a preferential transaction or whether any preferential treatment has been given to a particular debt. Yes, in case this process, CIRP process, is closed and a new process starts, in that new process, somebody can always say that this particular amount which was paid to this OC or this FC, this was a preferential transaction, but now this particular case is withdrawn. However, in case anyone feels that it is a preferential treatment to one person, any new CIRP, at that time, this can be considered as a preferential treatment, but not now, because this is only for the withdrawal of the process. So this is the answer for this question, and it's a very, very important question, because many times this is happening, that the promoters and the directors are making the payments from the account of the corporate debtor, because the IRP was not able to take the control and custody within the first few days. So therefore, they settled and they paid out of that account.
Then, so another question from Sanjeev Goel ji is that if Section 12A application is filed, how does it impact the proceeding or application filed against the PG? So PG insolvency is something that can
No,
stand alone. That
in
can
one of
stand
the
alone.
case, Ankit, I
Mm.
think this is an important question. In one of the case before NCLAT,
Mm.
it was decided by the NCLAT that once the CIRP, in fact, started,
Mm.
what happened is that the CIRP was started, application was filed, and also the application was filed for the insolvency of the PG. And later on, under 12A, the CIRP of the corporate debtor was withdrawn, but the NCLAT allowed to continue the insolvency of PG, saying that the time when it was submitted, the time when the application for uh, the PIRP, personal insolvency resolution process, at that time there was pending proceedings against the corporate debtor under the insolvency law. So that is the only requirement, and the requirement never says that the CIRP should continue or it should conclude, but it was pending at that time when the insolvency of the PG started. Therefore, the PG insolvency continued in one of the case of NCLAT.
Okay, so basically they kind of said that while it was filed at that point in time, the CRP process was actually going on. So that's okay. That's like a very factual thing. But technically speaking, in case you talk about a matter where the 12A is already settled, and after that that application is filed, then that application has to technically go to the DRT, not to the NCLT.
Yes, yes, yes.
Right, so that will be it's all about jurisdiction, and if the NCLT has exercised its jurisdiction, saying that yes, at the time of filing, uh, the CRP was already going on, that's perfectly okay.
So
Then, Mr.
you rightly said that if it is withdrawn and still somebody wants to file an application for the insolvency of PG, then this application technically will go to DRT as per the
And of
jurisdiction.
course, this is subject to the idea that the person who is filing this application still should have some debt or that PG should be outstanding. Because
No,
in
there
case
should
somebody
be
has
there,
done a
first of
12A,
all there should be PG partial
so in
granting.
case no, so in case 12A is done, settlement is done, then maybe the debt is already finished. So of course, the applicant has to be then somebody else, or it has to be a separate debt which has then become due to which default is not cured.
Yeah, yeah.
So then we have a interesting question that in case of Section 10, can 12A happen?
Yes, it is very well clearly written. In the case of Section 10, also the 12A can happen. Because in case we go and see Section
But the applicant here is the company.
no, the
Here
applicant,
12A will happen through the COC 90% voting.
no, Ankit, the Section 10 application is not only from company.
Hmm.
And when we see Section 10, this application under Section 10 can be filed in case we need to discuss this. So I can even see this section applicant. Like we have to see the applicant. Now the corporate applicant. Corporate applicant, in fact, means the corporate debtor. Next, a member or partner of the corporate debtor who is authorized to make an application for the CIRP or PIRP under the constitutional document of the corporate debtor. An individual who is in charge of managing the operations and resources, that means MD or CEO. A person who has the control and supervision over the financial affairs of the corporator, so that is the corporate applicant. When we say you see, in Section 10 application can be made by corporate applicant, and it can be made by the corporate debtor, it can be made by any shareholder, it can be made by the CEO, it can be made by the CFO. But it can still be settled. It is not that the company is making. Corporate debtor is defined very clearly. I hope I'm clear, Ankit. Corporate applicant. Let me again show it to the corporate applicant. So we actually can see corporate applicant. Corporate applicant, one that we can see in the definition, and the second that we can see is the initiation date, like the information, initiation date, the yes, initiation of corporate insolvency resolution process by corporate applicant. And the corporate applicant is defined in the code. So the corporate applicant is defined under Section 5, subsection 5 of the IBC. So therefore, the application can be filed by a CEO, application can be filed by a CFO, but that can be settled. That can still be settled. Still the company can come, still the promoters can come, still they can raise some money immediately, and they can control the debt defaults of the company.
Okay. Right. From Mr. Balakrishnan ji was that if the beneficiary of the bank guarantee is the CD, what is the use of such BG to the IRP? How will the IRP use that BG in case the beneficiary is the CD?
No,
Because the money will
let me
come to him.
explain. Let me explain this. The first the law says that the immediately IRP will take the control over the company and will take the control over all the bank accounts once the CIRP starts. And then in case any money is coming, the second what law says that IRP or RP will have to take his fee from the company, from the corporate debtor. So these are the two things that we all know. Now this bank guarantee is also in favor of the company. So in case there is there is no money and the bank guarantee would be invoked and the money will come into the corporate debtor's account, and then that will be drawn IRP, and then it will then the company and the bank accounts will be handed back to the promoters. So how can it is not only for the fee of the RP, the expenditure incurred after the commencement of the CIRP So the everything has to be paid by the applicant in form FA and as a bank guarantee. So that also there is also a possibility that when the IRP takes over the company, immediately takes over the bank account, and there are many expenditures, those are incurred from the bank account of the company only. Let us see that when this a company which is operational, a company which is operational, and immediately the insolvency starts, and there are bank accounts, there are transactions going on. What IRP will do? IRP will not spend from his own pocket. He will only spend the money from the company's bank account. He will only tell the company's managing director to release the money for the to the advertisement agency for releasing the for releasing Form A in the newspaper. He will not spend from his own pocket. So that money will be spent from the account of the company only, and then it will go back to the company, including the fee of the IRP-RP.
Okay. So, is it compulsory to give Form FA to the RP for withdrawal of the CRP? Yes, it is.
Yes, after this judgment of
Byju's judgment, yes.
GLAC in the case of Byju's withdrawal application, the Supreme Court has in fact clarified to a great extent that once there is a framework and that should be complied with. So that application must be filed by the applicant in Form FA along with the bank guarantee to cover the expenditures incurred up to the date of application and also estimated expenditures till the time the application is actually withdrawn. So that estimated expenditures, the bank guarantee has to be there.
So another question is that let's say 12-way application comes in and 2 months, let's say within the first 2 months, 12-way application comes in and 12-way application is also filed by the IRP before NCLT, and it takes 10 months for NCLT to process that 12-way. So what happens with respect to these 10 months? These are also paid for by the by
Absolutely, absolutely. So I would again, I will read for the benefit of the audience.
BG amount will change. How will this work?
No, I will read Regulation 30A. Now, let me read Regulation 30A, and I am reading uh, Sub-Regulation 7. It reads as where the application is approved and like so first of all it has to be the along with the let me see the guarantee bank guarantee clause. Okay, so after the constitution, and this is the like the sub regulation 2, the application under sub regulation 1 shall be made in Form FA of Schedule 1 accompanied by bank guarantee towards estimated expenses incurred on or by the IRP for the purpose of Regulation 33 till the date of filing of the application under Clause A of subsection 1 or towards estimated expenditures incurred for the purposes of clauses A, B, C, D of the Regulation 31 till the date of filing of the application under Clause B of Section 1. And then I'm reading sub-regulation 5. Where the application is approved under sub-regulation 6, the applicant shall deposit an amount. The applicant shall deposit an amount towards the actual expenditures, actual expenses incurred for the purpose referred to in A or B or some till the date of approval by the adjudicating authority. So the applicant shall deposit the amount of actual expenditure, even if it takes 10 months or 11 months and then you have incurred a lot of cost on the lawyers, till the date of approval by the adjudicating authority as determined by the IRP or RP as the case may be. Within 3 days it has to be deposited. So once this particular approval is coming from the adjudicating authority, immediately after that, it within 3 days all this money will be paid and the bank guarantee would be infructuous, and then the RP will draw within 3 days of such approval in the bank account of the corporate debtor, failing which the bank guarantee received shall be invoked without prejudice to the other actions permitted against the applicant. So what is important, Ankit? whenever there is any case where you are appointed as IRP, the very first thing that you should do on the very first day, file INC 28. So that in the records of the ROC, you are the person as the CEO of the company. Second important thing is that immediately ask the bankers that to operate the bank accounts with his instructions. So these two things are very important. Then let the company continue, let the company run, let the operations run. Now, when the application is coming from the applicant in Form FA, the bank guarantee would be given. Now, once it is approved by the adjudicating authority, then all the expenditures estimated till the date of the application, till the date of the approval of the adjudicating authority, all will be estimated and it will be provided to the applicant. Applicant will make that payment to the company's bank account, and then the bank guarantee will be withdrawn. In case the payment is not given, then the bank guarantee will be invoked. Now, the second question is that it will be, the money will come in the bank account of the corporate debtor. Whatever money has been already spent by the company, it goes back to the company, and whatever fee of the IRP, RP which has not been drawn, that also will uh, kind of drawn by the RP before handing over the company back to the promoters.
Right. Then, now, of course, we have many examples, as Shashiji is asking, that whether application under 12A can be made when approval of resolution plan or liquidation application is pending before AA. So we have
When the
cases where
liquidation order is passed, then
before
12A is
liquidation
not
order is
applicable.
before only liquidation application is filed.
When the liquidation uh,
Application is filed and pending with NCLT for
so
approval.
then 12A is possible. The
And when
only
resolution plan is pending for approval, even then 12 is possible.
no, then the consent of the resolution applicant is required. Because see,
Okay.
the one part is that the resolution applicant has no authority to withdraw the uh, resolution plan. So he
So if the
cannot withdraw
COC,
the
so if the
resolution.
COC has approved a resolution plan, it is pending with
When
NCLT
the
for
COC
approval. The
has approved
consent
the
of
resolution,
the consent of the resolution
not
applicant
even
is
the
also.
consent, not even the consent. The courts are not agreeing. Courts are saying that once you have approved the resolution plan, it should not be, it cannot be withdrawn. That is already it is a contract between the committee of creditors, and it should not be withdrawn. I think
Right.
we need to go ahead with that judgment
Yes,
finally,
yes.
where we actually, in fact, so then Ankit, then comes the after this insertion of 12A and 30A regulations, then there was a judgment from Honorable Supreme Court, and the title of the judgment is Abhishek Singh versus Hutamaki PPL. Hutamaki PPL, and this judgment came on 28th of March 2023. And in this judgment, finally, the decision of the Supreme Court was as under. 1. Rule 11 of NCLT Rules 2016 confers inherent powers on NCLT to pass appropriate orders for meeting the ends of justice or to prevent abuse of the process of the tribunal. The application for withdrawal was filed on 10th day. The NCLT ought to have immediately taken the decision on the application. Once the parties had settled the dispute even before the COC had been constituted, the application ought to have been allowed, and then and there rather await the other creditors to jump into the fray and allow the IRP to proceed further. So this is a case where the application for withdrawal was submitted on 10th day of the commencement of NCLT. However, the NCLT did not allow the withdrawal, and the RP constituted the COC. All the creditors, they jumped into the fray, and the these are the facts of the case. Now, the plea of the alternative remedy which was given in this case is a self-imposed restriction by the superior courts and is never an absolute bar unless barred by statute. The court held that in this particular case, they have entertained SLP itself and had granted the order of status quo. Substantial time has passed since then. As such, we are not inclined to entertain the said objections relating to the availability of alternative remedy. We may also note that IBC provides a statutory time frame for disposal of matters. Further, such matter being commercial in nature, keep matters pending for long frustrates the very objective. Violation of moratorium was also discussed. Claim of others was also discussed. Section 12A and 30A. So in this scenario, it was the finding which was recorded. And like, let me finally say, in this particular case, the conclusion was that for all reasons recorded, the impugned order of NCLT cannot be sustained. The application filed under Regulation 30 sub A of regulations deserves to be allowed. Accordingly, the appeal is allowed and impugned order of NCLT is set aside. Further, the application also deserves to be allowed along with the application under Regulation 30A. The application under Section 9 of the IBC filed by the OC shall stand withdrawn. So this was the case where it actually this was the case where it was unnecessarily prolonged, and therefore it was allowed to be withdrawn. And this particular judgment, even the Abhishek in the judgment of Abhishek Singh versus Hutamaki PPL, this was in fact used by Honorable NCL80 in the case of Byju's withdrawal. And the NCL80 said that even after insertion of 12A and 30A, the Supreme Court has upheld the withdrawal and use of the powers. Now, another case, in the case of Kamal K. Singh versus Dinesh Gupta, in fact, this was not a very kind of detailed judgment, which in fact, it was in fact criticized by the Supreme Court in the judgment of Byju's. And in fact, there was another judgment, which is Ashok G. Rajani versus Beacon Trusteeship Limited. And in this particular case, the same infirmity is found in this judgment by the two judge bench. According to two judge bench, the question of approval of the COC by requisite percentage of votes can only arise after the COC is constituted, and thus Rule 11 must be invoked to allow withdrawal. This observation was made without as much as passing reference to Regulation 30A, which specifically governs such a situation. So, in fact, when this Byju's judgment was given by Honorable Supreme Court, so these three judgments were discussed. They were saying that as far as the Abhishek judgment is concerned, Abhishek Singh's judgment was correct, because that was only referring to, like, once the application is made, it should be immediately decided, and the COC should not have been allowed to be constituted. The other creditors should not have been allowed to jump in the foray. But when this judgment of Glass Trust Company LLC versus Byju Ravindran, this judgment came on 23rd of October 2024 by the erstwhile Chief Justice of India, Dr. Justice Dhananjay Y. Chandrachud. That particular judgment, in fact, reiterated that whatever has actually happened, like in this case, NCLT rejected the withdrawal, NCL80 allowed the withdrawal, and finally the Supreme Court, in fact, again rejected the withdrawal. So this is a scenario. In fact, we already have conducted a webinar only on this particular judgment, and finally we actually say that in this particular case, the questions that was framed by the Honorable Supreme Court and the observations and the decision of Supreme Court was that NCL80 should have stayed with the constitution of the COC and directed the parties to follow the procedure in Section 12A read with Regulation 30A. That's what is the first observation of Honorable Supreme Court. The Honorable Supreme Court further found that NCLT erred. NCLT made a mistake in invoking its inherent powers to approve the settlement without following the prescribed procedure for the withdrawal of CIRP. It also stated that other creditors, like the appellant, had no right to be heard in a settlement case between the corporate debtor and the BCCI. But the court emphasized the following aims and objectives of the IBC. It's like, I may even say that this GLAS was another creditor. He was, this particular party was not even applicant. It was not respondent, so it was not a party. But it actually filed an appeal. So it said like the appellant had no right. So the aims and the objectives of the IBC was also narrated. The consolidation of the pre-existing fragmented insolvency framework to eliminate parallel proceedings by various creditors, implementation of the principle of collective distribution ensuring proportionate share, prevention of IBC use as a tool for coercion and debt recovery by individual creditors, separation of interest of corporate debtor from those of its promoters, management, preventing. So this is the court highlighted all these principles, and 4 stages of withdrawal of CIRP was clearly defined. Whatever is mentioned in section 30A of the regulations of 30 regulation 30A, that was again identified and it was reiterated, highlighting that the legal framework mandated an application for withdrawal through the IRP to be placed before NCLT. One, before the application under section 7, 8, 9, or 10 is admitted by NCLT. Therefore, if the application is what it says, before NCLT admits a creditor's application to initiate CIRP, it may be withdrawn under Rule 8 of the NCLT Rules 2016, subject to the tribunal's discretion. A CIRP has not commenced, the proceeding remains in personam. Proceedings remains in personam, involving only applicant, creditor, and the corporate debtor. Thus, when considering withdrawals, NCLT typically restricts its inquiry to these parties as other creditors are not yet stakeholders. Second, when the application under section 7, 8, 9, or 10 is admitted, but before the COC has been constituted. After the application is admitted, but the COC is formed, before the COC is formed, the applicant can seek withdrawal by submitting a request through the RP to the NCLT. At this stage, the proceedings are in rem. At this stage, the proceedings are in rem, involving all concerned parties, not just the applicant, creditor, and CD. The NCLT must apply judicial discretion, considering all relevant factors and hearing all parties before deciding on withdrawal, rather than merely approving settlements without scrutiny. Law, what it says, even before the COC is formed, even before the COC is formed, NCLT must apply judicial discretion. It must hear all others and then only permit, because the word written there is may. Now, the third scenario or stage is when the application is submitted and the COC has been constituted. Then, of course, same process, but voting of the COC with 90% of the voting share is required. That is, application has to be submitted again through the RP. And fourth, an application is admitted, the COC has been constituted, and expression of interest has been issued, Form G has been issued. That is also same, but the reason why the form, why it was delayed, that has to be mentioned. So these are, the Supreme Court found that these requirements were not met in the case of Byju's, citing a lack of formal application, a direct approach to NCLAT by a formal director instead of through RP, and seeking settlement approval during appellant proceedings instead of before the NCLT. The court criticized the NCLAT for not providing reasons for deviating from the procedure or justifying the urgency to approve settlement without following this process. The Supreme Court, in fact, decided. What is decided? That we are of the view. The Supreme Court said, we are of the view that recourse to Rule 11 of ANCLAT rules was not warranted in the present circumstances. As noted, the inherent power cannot be used to subvert legal provisions which exhaustively provides for the procedure. To permit ANCLAT to circumvent this detailed procedure by invoking its inherent power under Rule 11 would run contrary to the carefully crafted procedure for withdrawal. In the impugned judgment, ANCLAT does not provide any reasons for deviating from this procedure or the urgency to approve this settlement without following the procedure. So therefore, the conclusion was in fact very clear. But when another judgment, because the time is short, I would only say one thing. But when the other judgment was passed after the judgment of Byju's, in the case of State Bank of India versus the consortium of Marari Lal Jain versus Flori, Frich, that is in the case of the insolvency of Jet Airways, and it was held that the judgment of Glass Trust Company LLC should in no manner be read as to restrict the exercise of plenary powers under Article 142 of the Constitution, even while in deviating from the statutory procedure and framework of the IBC or the rules and the regulations made thereunder, if such deviation is very much necessary. So finally, after the judgment of Byju's withdrawal, came the Jet Airways judgment. In Jet Airways judgment, the bench says again that whatever we have said in the judgment of Byju's, that should in no manner be read as to restrict the exercise of plenary powers under Article 142 of the Constitution, even while deviating from the statutory procedure and framework. So this was very important. This was in fact important to the extent that the it has to be used in some circumstances just to meet the ends of justice and also to prevent the abuse of any process. So this is what, Ankit, all about it. In fact, we can take one or two questions because the time is already up.
So three quick questions. So one question is that during 12-way withdrawal process, let's say 12-way application is now filed by the RP and it is pending for adjudication before the NCLT. So what are the duties of the IRP or the RP during this time? The application is pending for approval at NCLT.
No, see, the first part is once the insolvency commences, all the duties of the IRP has to be done. And nobody can say that the IRP will not do the duties till the time the application is admitted by adjudicating authority, like taking control and custody of the assets, taking control over the bank accounts, allowing the company to continue as a going concern, preserving and protecting the assets of the company. These are the duties of the RP. RP will continuously do that. And in case the claims are being submitted, the RP will also continue to collate the claims. In case there is no stay from the bench for constitution of committee, the RP will also constitute the committee, even if the application is pending before NCLT, even if the application was received in form FA along with the bank guarantee, even if all the compliances are done, but if there is no stay, then the RP will continuously do all the jobs as per the timelines given in the IBC and the regulations. Because otherwise, RP is not sure whether the application under 12A would be accepted or it would be rejected by the court. Therefore, the time cannot be wasted. RP has all the duties to continue all the processes.
Right. So he will continue to run the company as a going concern, but he will perhaps not go for an EOI. He will not start the process to get the valuation done.
No,
Uh,
in case the
he
withdrawal
will.
is litigated, and it takes, say, 1 year, I don't think the RP can stop going ahead with the process.
So
RP
his
will
duty
go
is
ahead
to
with it.
propose all these things, propose a
His
valuer,
duty is to
propose a
propose all
transaction
these things.
auditor, propose the EOI. But if the creditors say no, then that's a separate issue.
Yeah,
But his duty is.
in case the COC is constituted, then the creditors will say no.
Hmm.
But his duty is to continue with the process, timeline.
So he will, of course, propose all the things as per the timelines.
Absolutely.
Second question. So in case 12A is proposed and 12A is proposed, and the RP has filed the withdrawal application with let's say 90% COC approval, or with maybe if the COC is not constituted. So, and this, let's say this is done within the first day itself. Can he choose not to issue the public announcement, or it can happen only if the NCLT orders that okay, it should not happen as an interim order?
I think when on the very first day, the form FA is received and it is submitted to NCLT, the RP can take a little lenient view, considering the status of the company, and immediately when the application is listed, the RP must ask the bench whether he should go ahead with the publication of Form A inviting the claims or not. But in case nothing is said, simply by filing an application for withdrawal should not be considered as the withdrawal has already been done. It should be considered that the NCLT may or may not allow, because the Supreme Court is very clearly saying that simply by settling with one creditor has never been the objective of the IBC. The objective is the NCLT is under obligation to make an overall assessment and then accept the withdrawal applications. So therefore, the RP is under obligation to continue with the process, meet with all the requirements and timelines of the CIRP.
So another example, that in case one X, let's say, initiates an insolvency process, insolvency starts, COC is constituted. Now 90% of the COC says that okay, this application 12A, they accept a 12A proposal, and that 90% does not include the original applicant. That does not make any difference, right? The original applicant is not important
You see,
anymore after COC
it
constitution.
depends if the original applicant is a financial creditor or an operational creditor.
Mhm.
Now, the committee is constituted. Committee can be constituted in case somebody's filed a claim and the claim is collated. So the committee will be constituted exactly on a different premise, not based on the application or the applicant. Committee is constituted based on the claim.
Based on the claims, yes.
So the committee will be constituted with or without the applicant. That is not a concern here.
So what I'm trying to say is that the original applicant is of no concern. So if an OC initiates an application and all the FCs together say that
All
no,
the FCs can say
we
yes.
don't want IBC to take over this company, they can say, but they will have to establish that the company is solvent or no.
No, see, like what I say, that COC is constituted and that person is not being paid any amount, and the COC says that yes, we vote for withdrawal without even that applicant, and the company is solvent, and then application can be withdrawn, and no bench or nobody can insist that before the COC is deciding for withdrawal. But then the question is, the applicant must be filing an application under Section FA. The COC cannot decide without Form FA, and which has to be submitted by applicant only. So that's
even after COC is constituted,
absolutely.
the FA has to come from
FA
the.
has to come from the applicant.
But the withdrawal by 90% of the COC is subject to the applicant's application
It
under
is
FA.
subject to the applicant's FA, a Form FA. It is not otherwise. Form FA is mandatory, and Form
Even after
FA has to be given
constitutional
by the
COC.
applicant.
So then this is not
This is
practically
not
possible
practically possible.
without
The
the.
procedure doesn't allow that. Sorry.
So I think we on time. We still have a lot of questions today. A lot of questions have come because this is, I believe, a very important topic these days.
It's
So
very
we
important topic that we actually see. Ankit, the next episode, we are coming up with the very hot topic regarding the attachment by investigating agencies, enforcement directorate, CBI, economic offense wing, SEBI, and whether this Section 32 capital A, which was inserted in IBC, whether that is impactful, whether that can be invoked, whether that is. So all that presently, what is the total trajectory of Section 32A and that is what we are going to discuss in the next episode. And we are preparing for it, and we are making hard work. We're trying to collect all the latest judgment on it. So therefore, please do join. Yes, Ankit.
So I think we should close. We are already ahead of time, so time is of essence. So we can take the remaining questions offline if anyone would want to, share any questions. We will be happy to take them.
See, we actually have a full-fledged law firm now, AAA Legal Professionals LLP, and we are taking up the cases where we are not the RP or the liquidator. So that law firm is fully functional from our Oakland office. Very much for joining. It is our way of learning. Thank you.
Thank you.